Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am here with you each and every week at this time on this station to bring you, the landowner, the information that you need regarding natural gas development here in the Commonwealth of Pennsylvania. At the Clark Law Firm, and boy, don't forget it, I represent Pennsylvania landowners, royalty owners. I have not, I do not, and I will not represent oil and gas companies. I represent the Pennsylvania landowner and royalty owner, and very, very proudly do I do so, and very proudly do I say that. I represent landowners and royalty owners for any and all issues related to natural gas and natural gas development, including but not limited to royalty issues, royalty deduction issues, gas lease reviews and negotiations, of course, pipeline and water line agreements. And I have to say it again, at this point, I think we're around 60 to 70, we'll say around 50, 60, 70 different companies that I have reviewed, negotiated with, consulted with my clients, the landowner, the property owner, in pipeline-related matters, which gives you an idea of the pipeline work and activity that's out there. And as we move forward, I've been doing the show now for 7 years. We've been doing All Things Marcellus, this show, with me since August of 2010. So we are now past 7 years of doing this show, which gives you, again, the idea, the information to realize what is out there, what is occurring, and I believe demonstrates the need for our landowners, our property owners, our royalty owners to get assistance to help you. I will continue to say, because I see it virtually every day, in my opinion, landowners being taken advantage of. And I want to make this super clear. Let me make this very clear. In my opinion, Doug Clark's opinion, I believe that our landowners, our property owners, and our royalty owners are being taken advantage of on a regular basis. And how is that occurring? It's because our landowner, property owner, and royalty owners do not have the information they need. They are not as informed as they need to be, and they're getting their information from the other side. When you are in negotiations, you should not, in my opinion, be taking the information that you're judging and making decisions from solely from the other side, who is motivated to do the best they possibly can for their side. That's okay. That's the process. Recognize the process. Our job, our goal, what we need to do from the landowner, property owner, and royalty owner's perspective is the best we can for our side. The company's going to do the best they can for them. We need to do the best we can for us. And I don't say it lightly that I think people are being taken advantage of. I see it, again, my opinion, I see it all the time. I see people sign agreements and then come to me on another matter later on, and they provide me their prior agreements, and I just quietly shake my head to myself and say, man, I wish we would have talked. I wish I could have talked to you before you signed this other agreement, because we could have made it, in many, many cases, significantly better. Added compensation, literally tens of thousands and sometimes hundreds of thousands of dollars. Not every case. Not every case. I'm not a person who's going to sit here and say, oh, call me, I'm going to get you hundreds of thousands of dollars more. No, I can't guarantee you that. Nobody can. But I can tell you this, many people have called And from the initial offer to what they signed for after they called, the increase in many times, many times, tens of thousands of dollars, and many times hundreds of thousands of dollars. That occurs far more often than you would think. Now, again, I want to make it clear. I'm not saying you call me and all of a sudden you're going to get hundreds of thousands of more dollars. But what I am going to tell you is you call me and you're going to get the best information that I can give you by somebody who's doing this all the time from your side, fighting for you, the best information that I can provide to you to assist you, to educate you, and inform you to make the right decision for your situation, and to inform you of your leverage, of the market, of what you might expect, of what you might be able to accomplish. And I don't care where you're located. I have clients in southwestern Pennsylvania, western Pennsylvania, north central Pennsylvania, northeastern Pennsylvania, any and all gas-producing areas or anticipated gas-producing areas. We need to get to you this information so you make informed, intelligent, educated decisions, and you maximize, you hear me say it all the time, maximize the opportunity that is presented to you, whether it's a pipeline agreement opportunity, a lease opportunity, many other things, surface sites, roadways, any of these things. We need to look first as an opportunity. We need to say, okay, this is a potential opportunity. It may be a potential opportunity that I simply decline because I'm not interested, regardless of the money. Or maybe it's a potential opportunity that I negotiate and I attempt to increase the compensation or the money that I'm going to receive. We need, on the landowner, property owner, royalty owner's side, we need to identify opportunities, identify leverage, maximize the opportunity, understand our rights, and get this, not simply rely on the landman who works for the company, not you, the landowner. The landman, I know I preach it all the time because it's so darned important. That landman, it's the truth. Nobody on the planet can dispute this. Unless you've hired them, they're not working for you. They're working for the company. That's the deal. Understand it. Understand it. They're not going to come out there and start typically being mean to you, holler at you, be aggressive. No. You want someone to sign a document, how are you going to treat them? How are you going to communicate with them? You need to understand their job. And again, they have a job. That's okay. We need to understand their job, and we need to understand that we need to protect ourselves, and we need to cover our interests. And here's the thing. I'll tell you this. I represent a landman right now, a landman from a different state who has interest in Pennsylvania. I represent them. Why? Because this person knows that they need to get assistance. They need to get assistance because they recognize how the industry operates. To me, that's a really powerful thing. When a landman from another state with gas interest in Pennsylvania calls my office for representation for oil and gas lease negotiations, why are they doing that? Why is a landman who's been in the business for many years, why are they hiring a lawyer who works in the oil and gas field? Ask yourself that. And ask yourself, why am I not going to a lawyer? And look, I'd love to talk to you. I love what I do. I love representing people, and I want to fight for people all the time to make sure we're doing the best we can for us. But if you don't call me, call someone. But we can't let this continue. We can't keep signing pipeline right-of-way agreements for $10 and $15 a foot when we don't even understand our leverage. We can't do that. We can't do that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can call me and find out about representation, find out about reviews and consultations. 570-307-0702. 570-307-0702. Give us a call, any oil and gas related matter. See what we do. And again, too, I don't promote these, I think, enough on the website, or the websites on the radio show. But I really encourage you, if you have not done it, or if you have, go to it again. 2 websites we have, pagasleaseattorney.com. That's pagasleaseattorney.com. And remember we talked about pipelines? pipelineattorney.com. Think about it. If you have a pipeline right-of-way agreement presented to you, why would you not, again, you should call someone, but go online and become educated. Go to pipelineattorney.com and become educated. Also, you can learn what we do. If you like what we do and you think we might be able to help you, give us a call and see what we do and see if we can help you. Again, 570-307-0702. But I'm going to say this. I say it all the time. And I tell you, I really, really mean this. If you do not call me, Attorney Doug Clark, call someone. Call another attorney. And how often do you hear people say that? And I'm not saying that for kudos for me. I'm saying that you, in my opinion, need representation. Go to the Penn State website. Look at that. Read that. They say, get representation. There's a reason for that. There is no doubt in my mind that representation versus non-representation, non-represented Pennsylvania landowners over the history of the development of the last 10 years have easily, in my opinion, have lost out combined cumulatively well into the hundreds of millions of dollars because they weren't represented, because they believed in the landman. Oh, you don't need an attorney. They thought, hey, I can do this. I don't need an attorney. Oh, the attorney's going to be really expensive. I never had an attorney before. Why do I need an attorney? Other people did it without an attorney. Well, again, I used to hate it so much as a kid in grade school when the teacher would say, well, if everybody jumped off a bridge, would you do it too? Yeah, I mean, I'm sure there's a lot of listeners that hate that expression too, because, I sometimes got in a little mischief when I was in grade school, and it would drive me insane. But as you get older, you understand, hey, there's a reason why people say it. And the reason why people say it is because it's true. If 25 people, if 100 people make a mistake, how in the heck does that justify you repeating that mistake? It doesn't. It doesn't. You're listening to All Things Marcellus with me, Attorney Doug Clark. When 100 people make a mistake, when 5 people, when 25 or 50 make a mistake, what do? We learn. We learn from the mistake, and we do not repeat it. We learn from the mistake, and we do not repeat it. Because my neighbor signed a garbage pipeline agreement, garbage, for $10 or $15, does not mean at all that anyone else should repeat that mistake. What it means is that you, as the person who is aware of this, learns from the mistake and you don't repeat it. We don't repeat the mistake of others. I had it again this week, and I'll tell you, it makes me nuts. It makes me absolutely crazy when I hear, well, this is what we've signed. This is what everyone in this area signed for. In pipelines especially. Well, the neighbor signed for this, or this guy signed for this. I don't care. I don't care. It's relevant in some respect because we're looking at market conditions, and it factors into the overall evaluation leverage assessment process. However, I have had several clients receive hundreds upon hundreds of dollars per foot for pipeline rights of way. I've had it many times. And if we listen to, well, all we paid is $10 a foot or $15 a foot or $25 a foot, well, they wouldn't have got $200, $300, $400, $500, $600, $700 per foot. Now, I want to stress, you have to. That's not the normal. You don't normally get $500 a foot. But in some cases, you can. And imagine if you signed a pipeline right-of-way agreement for $20 a foot, 25, 10, 15, when you could have signed it for $100 or $200 a foot. Had you understood your leverage, you went through the negotiation process, you maximized, remember, an opportunity, and you signed literally 10 times higher, 20 times higher, maybe even 30 times higher. I stress again, this isn't every time, but it's part of this process that does occur. So you'll hear me talk about reviews and consultations. Generally, even a pipeline agreement, you get a pipeline agreement, give us a call. We set up, you can come to the office. I love when people come to the office, but you don't need to. We do these by telephone. I have clients, again, in Texas, Florida, and all over the country and in different countries over the years. And we do them by telephone. We get the paperwork. We assess the leverage. And we have a discussion and formulate a plan. And maybe that plan is, hey, look, I don't have to do this. I don't want to do it. Thank you, but no thank you. Maybe that plan is, hey, you have a lot of leverage here. And thank heavens you called me, because you're being offered $10, $15, $25, $30 a foot. And I think that this is more likely a much, much higher per foot or compensation than what's being offered at the present time. And those are things that we talk about in reviews and consultations. And again, I've represented hundreds and hundreds of people in pipeline right-of-way agreements. Whether you call me, call somebody that knows what the heck they're doing so you can identify your leverage and maximize your agreement. And do you think that's what the landman is doing in your kitchen? Making sure that you maximize the agreement, making sure that you get every ounce, penny, dollar of compensation that you can possibly get, to make sure that you're given every single property protection term, minimizing operational authority by the company, saying, hey, you can't do this, you can't do that. Is that what the landman's doing at your kitchen table? I don't think so. I don't think so. And I'll tell you, in my experience, that's not been the case. That's not been the case. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call, 570-307-0702. I don't care where you're located. Very active now in Tioga County, very active clients in Washington and Greene, Susquehanna, Bradford, and so on and so on and so on. No matter where you're located, give us a call, see if we can help you. That's what we do. I don't like to sound hokey. I don't like to, but it matters. It matters. I think it matters because I know it matters to me. I grew up, again, right on, I'll tell you, Airport Road, Armstrong County, Pennsylvania. Father worked at Allegheny Ludlam Steel Mill. His dad worked at Allegheny Ludlam Steel Mill. Small farm. That's why I love what I do. I love what I do because I don't want to see people like my grandfather, people like my father, people like all the other people who grew up and lived on Dime Road and Airport Road being taken advantage of by big companies because these people were not informed. I want to get you that information. That's what I want, and I want to make sure that all Pennsylvania landowner, property owner, and royalty owners are maximizing their opportunities and their circumstances. Give us a call, 570-307-0702. You're listening to All Things Marcellus, again with me, Attorney Doug Clark of the Clark Law Firm. Join us each week, every week, at this time on this station for All Things Marcellus. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I want to thank you, as always, for joining us. Been doing the show now, pretty proud of this, 7 years. I've been doing All Things Marcellus, the weekly radio show to provide information and education to landowners, for 7 years, and we're not stopping. And by the way, if you can't catch the show each week, if you say, what the heck, this is the first time I ever heard this show, check out our websites. We archive the radio shows on the website. If you can't catch the show each week at this time on this station, check out the websites on Monday. pacastleaseattorney.com, pipelineattorney.com. Check out the websites. We archive the shows so you can listen to what shows you're interested in. If you want to hear a show about pipelines, you want to hear a show about gas leasing, royalty deductions, buying and selling gas rights, anything, pipeline, like I said, pipeline, water line, leverage issues, check out pagasleaseattorney.com. Check out pipelineattorney.com. Use the websites, use the radio shows as a resource. Remember, neither the radio show nor the websites provide specific legal advice for anyone, but they are out there to provide general information and knowledge to add to your knowledge base when you're dealing with these issues. Again, we want to hear from you. I want to hear from you. However, even if you don't call, use these resources. I truly want everyone to do the best that they can. Use the resources. Use them. They're there for you. You're listening to All Things Marcellus with me, Attorney Doug Clark at the Clark Law Firm, and you can join us each week at this time on this station. So, okay, I want to talk some now. I got a little bit. I get fired up. I'll tell you. I'm so tired of people being what I see as being taken advantage of because they're uninformed, and because they don't reach out for assistance. And that's why I say, reach out, give us a call. If you don't like what you don't hear, or if you don't like what you hear, then that's okay. Don't call back. There's no forcing here. We never force anyone. We're here to help people. And, look, if you don't believe, I think you might believe it, but if you don't believe it, go check out, again, the websites. Check out the testimonials. I am so proud of our websites and those testimonials written from our clients. And we're going to continue. We're going to continue to fight the fight for the property owner, the landowner, and the royalty owner. All right, so what am I going to talk about today here in some substance? I'm going to talk about some leasing terms, but there's this one. I want to talk about what we call as operations, and I want to talk about shut-in provisions. And we're going to talk some more about other items as well, but let's talk about shut-in and operations now. And we'll say also the length of your lease. Sometimes when you're in a business or you're dealing with something all the time, you start to take things for granted and you think, hey, everybody knows this. Well, one of the things that I find that I sometimes take for granted is that everybody understands, okay, I signed a 5-year lease, or I signed a 5-year lease with a 5-year option. And they believe, okay, well, in 5 years, no matter what, we'll reset and say they sign a 5-year lease. The lease has a primary term of 5 years. So they sign a 5-year lease, and they believe that in 5 years, that lease ends no matter what. Look, that's not a crazy concept. You sign a 1-year lease to rent an apartment. At the end of that year, you need to either enter into a new lease or you're going to have to move out of the apartment. So generally, throughout our lives, contracts that have a certain time frame, like 1 year, 5 year, whatever that time frame is, that's the length of the contract. That's what we understand. That's what we commonly see. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So, okay, then you get an oil and gas lease, and it says 5 years. And you say, okay, well, in 5 years, this is going to end. Well, that's I say of course. That's not necessarily the case. And the question becomes, well, what has to happen? How does it go beyond 5 years if it's only a 5-year lease? I mean, I see right here, it says term 5 year, primary term 5 years. Well, again, the key is primary term 5 years. That essentially means, okay, this is paraphrasing, making this simpler. That essentially means that the company has to do something, conduct what are called operations within 5 years. Now, we have to ask the question, what is operations? What do they have to do within 5 years? Well, operations, of course, is a moving target. It depends on the lease. It depends upon the language of the lease. Some leases are extremely company friendly, and they define operations within the lease. Hint, we need to read these leases and understand each and every word. They define operations in the lease as maybe as simply as filing for a permit to drill. That's really, most people wouldn't think of that as an operation. Filing for a permit, filling out the paperwork, filing for a permit. So if they filed for a permit by the end of 5 years, so it's the 4th year, last day, and the company files for a permit and creates a unit where it includes some of your property in the unit for the area where they've just filed for a permit. Well, many leases, that means that you are now what they call held, and that lease will continue. So they have 5 years to conduct operations. We need to understand what operations are. In some cases, in many cases, operations can be as little as filing for a permit. So if within 5 years the company conducts operations, which again, filing for a permit, in some cases, constructing an access road, work preparation to construct a well pad or an access road. We need to really look at what these operations are, because the least amount that is required, obviously the better for the company. So when you sign a 5-year lease, you need to understand what's the likelihood that my lease may expire in 5 years or continue. And in many cases, it's going to be unlikely that it's going to expire. Now, that's not necessarily bad, because it may be that within 5 years, not only did the company file for a permit, maybe they actually obtained a permit and started the drill. And boy, how about this? Maybe they drill and they start producing gas and you start receiving royalties. That's great. That's wonderful. That's why you do it. That's why you're doing it, for the bonus and the potential and the hope of future royalties. So that's a good thing. That's our bargain. We're saying, hey, we're going to lease 5 years. That gives you the 5 years to conduct operations. And we're going to try in the negotiation process to not just say filing for a permit is enough. We're going to say that you need to be drilling within 5 years. Ideally, you'd want to see them producing within 5 years, but that's probably not something that you're going to be able to attain in today's market. However, there are many times, even this year, even as we sit here today, where companies will agree that they must be drilling within 5 years. That's a big difference between filing for a permit, waiting for the permit to be issued, mobilizing, and then commencing the drilling process versus actually drilling. Big difference. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure that you tune in each week at this time on this station for All Things Marcellus, and give us a call. Potential representation. You want to learn more, you want to learn about representation, 570-307-0702. That's 570-307-0702. No matter where you are located, if you have property, royalty rights in Pennsylvania, give us a call, see if we can help you. Remember, I have not, I do not, and listen please closely, I will not represent gas or pipeline companies. I'm representing Pennsylvania landowners and property owners. So jumping back here now, so we're looking at the term. You do a 5-year lease. And what I find troubling at times, I'll have people call me and say, hey, my lease expires next week, and I'd like to talk to you about negotiating a new lease. And we say, okay, well, where's your property? What's going on? And we find out that the property is actually already included in a unit and is actually even receiving royalties, the person is. But they still, unfortunately, mistakenly believe that their lease expires in 5 years, because that's how long, or that's the term of the contract. When they read it, it says, oh, this is a 5-year lease. No, remember, it's 5 years to conduct operations. And once they start producing gas or conducting operations and then go forward with what's called due diligence and then start producing gas, this lease goes on indefinitely until there's no longer gas being produced. And typically how it's worded is, and it goes on, and it could be 50 years or 100 years. It could be, who knows? I mean, it could be 500 years. It might be 20 years. But it continues until there is no longer gas being produced or gas capable of being produced from your what's called leasehold or your property and the unit or units which your property is included in. And that can be a very, very long time. So it's unfortunate, but there are many people that are holding leases that have 5 years terms and think, okay, great, this is going to expire. I signed and maybe I only had 12.5% because maybe it's in an option period, so it's actually around 10 years. So I only have 12.5%. This is great. I had a 5-year lease with a 5-year option. Now we come into we're in year 10, and so I'm like, hey, great, this is going to end. But the reality is, no, it's not going to end because they've commenced operations or maybe even they're paying royalties. And that lease then I always look at as being locked in for what I would say decades upon decades. So again, it gives you an idea of the importance of many things. One, to understand your lease thoroughly. The 5-year primary term or 5-year term is a fundamental basic concept. And when people call and they don't understand that they have a 5-year lease and operations need to be conducted in 5 years, and then if they are conducted operations, it continues, it amazes me because I know then that when they signed this lease, they didn't really understand it because that's one of the most fundamental concepts of the lease. And that tells me, wow, when they did this, they weren't very informed or they would have known how this would have operated. And I can sure as heck tell you, again, this is like one of the most basic concepts that you would understand, and you need to understand it. And if you have an attorney who's assisting you, knows what they're doing, you're sure as heck going to understand it. But again, that's the most basic concept. We have so many other items: royalties, royalty deductions, royalty calculation method, affiliated sales of gas, and the use of index pricing, surface use, surface restrictions, all kinds of additional items, pew clauses, shut-ins, all kinds of additional items that we need to address and understand prior to going forward. This, again, is typically the property for most people. I know for my family, the family farm, small family farm, largest asset our family has. Largest asset my grandparents had, my parents have. Largest. So we're not going to fool around. We're going to make sure that when we're dealing with our largest family asset, we're going to do it properly. Because again, if you have 100 acres and you negotiate and you're able to get an extra $500, you just made immediately $50,000 more dollars. You need to understand, do you have the ability and do you have the leverage to negotiate, and what type of final number might be reasonable? You need to have a strategy, a negotiation strategy. Then you need to negotiate the other addendum terms. You know, the difference between royalty and royalty without deductions, boy, that can be unbelievably substantial. That can be super substantial. I mean, super substantial. And one of the things, you know, got a guy from a company communicating with me, or not actually, we'll say a landman, say, oh, well, yeah, this company only takes these deductions. Again, you may hear that, say, oh, that sounds great. Oh, this company only takes these deductions. Well, who says this company is the company that's going to actually operate under your lease or not sell it, assign it? Who says that this company is not going to change positions going forward? Who says that this is how the company is going to act as they go forward? If this is all the deductions you take, then let's put that down in writing. Oh, well, we can't do that. Well, why not? Why not? And I hope that any regular listener knows that they can't do it because they need the option, because they may change or they may never do it the way you're being told they do it. And if you don't protect yourself, you don't protect yourself. And I'll tell you this, I'm in court cases. I'm in negotiations with company lawyers on a fairly regular basis, dealing with company lawyers and saying, well, they signed it. They could have negotiated it. Read opinions. I mean, I don't expect everyone to go out and start reading court opinions, but I'm telling you, I read them, and they say, hey, landowner should have negotiated it. They agreed. Companies read these opinions. You're not. You better have somebody working for you, that's reading these opinions to help you. Or, talk about, an unfair process. Somebody with all the information, all the experience, all the legal background versus you, and they send their trained representative out to deal with you, and you're going to go in with the largest asset of your family, and you're going to think about future generations, your children, your grandchildren, your family, your farm, your property, and you're going to go and wing it. You're not going to understand these other issues. You're not going to understand how royalties are going to be calculated in affiliated sales and deductions. You may literally again, you got to look at each case individually, but you may cost yourself hundreds of thousands, depending on the size of the property, literally potentially millions of dollars. Again, I'd love to hear from you. We do reviews and consultations that take about an hour or two. I get very afraid that people are afraid to call, not just me or any lawyers. Oh, it's going to be expensive. Oh, this or that. Give us a call, find out what we do, and see if we can help you. And then if you don't like what we do and you don't think we can help you, or that we can help you, then that's okay. I suspect that you might think that we can help you, and I'm pretty sure that I can. However, and if I don't think I can, I tell you this, I promise you, I'll tell you right away, immediately. First thing out of my mouth, hey, look, here's the situation. I don't think I can help you. That's rare. But if it happens, if that's the case, that's what we do. We're not in a business to take people's money. We're not in a business to treat people unfairly. I'm in the business of helping people. Now, any lawyer, look, I have 2 kids, college. One just started law school, by the way. I'm very excited about that. Started his first year. So we're looking at another Clark. We'll see what he gets into as far as the practice. But we want to help people. I make money and make a living with my job, but the greatest part of my job is that I get to help people like my grandfather, like my grandmother, like the other people who I know, my relatives and friends on Dime Road, Airport Road, Armstrong County, where I grew up. I get to help people like that every day. And that's the gift of my job. I love that. And I'd love to help you, and I mean it. And again, though, but if you don't want to call us, call somebody. But our number, 570-307-0702. 570-307-0702. You're listening to Attorney Doug Clark, that's me, with All Things Marcellus. Join me each week at this time at this station for All Things Marcellus. I'll be right back. We got 2 more segments to go. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can give us a call at the office. Learn about representation. Learn about reviews and consultations. We're here to help. 570-307-0702. That's 570-307-0702. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, where I represent landowners, property owners, and royalty owners. Do not, have not, and will not represent gas or pipeline companies. So last segment, we were talking about the term of the lease. Just real quick, if you have a 5-year lease, that means the company has to conduct some type of operations within 5 years. Operations, we may think, hey, that means doing something significant. But operations is what's called a defined term. It is given a definition in the lease document. And the definition may be as little as simply filing for a permit within 5 years. We have to understand that. And what do we want to do? We want to limit that time frame, whether it be 5 years. If there's an option, we want to generally eliminate that option. But we want to reduce that time if we can. And then we want to try to add language that's going to address what has to occur within that 5-year period. And if possible, we want to tighten it up. We want to have drilling. We don't want to have just filing for a permit. And listen, sometimes you're not able to change that. Sometimes you are. But that then becomes part of that factor. You know, you think of this giant scale. Well, 5 years filing for a permit. Well, you know, it's not the greatest thing in the world, but hey, it's not necessarily the straw that's going to break my back in deciding whether I want to do this. Now, if I'm offered, you know, $500 and 12.5% full deductions, then, you know, that's going to just be part of this scale. We're going to say, okay, here's some good items, here's some bad items. And again, those are things that we would be talking about through the review and consultation or continued representation. But now let's talk about this shut-in provision. And I'll tell you, especially Tioga County, I have not seen anything anywhere in Pennsylvania like I see in Tioga County. And to me, it just really, honestly, really saddens me. This is me personally talking. Makes me very, very sad to see what I see occurring in Tioga County, Pennsylvania. Now, they're similar, but never to the degree that I see in Tioga County, Pennsylvania, where what happens and what happened was that people signed leases. Maybe they were a 5-year lease. Maybe they were a 5-year lease with a 5-year option that the company could extend the lease for another 5 years. So they would have now up to 10 years to conduct operations. Well, what we've seen happen in Tioga County is, and I'll say, look, East Resources first, then sold their leaseholds to Shell, also known as Sweppy. They drilled many vertical wells. They go out, they construct a pad, and they drill a straight down. They don't go horizontal, they drill vertically. And they drilled typically down to the Marcellus formation. Then they create these large units, and they say, we'll say 5 years, let's pretend we have a 5-year lease. We, within 5 years, have drilled a well. And now, and let's pretend that well was completed. We'll just make this simple for discussion. That exactly on the last day of the 5th year, that well was completed. So what we have is we have a completed well that's a vertical well that is now done at the end of 5 years. Well, generally speaking, these companies aren't producing from these vertical wells. Well, why drill a vertical well if you're not going to produce from it? Well, I'll tell you my opinion, and boy, is it a strong one. Well, because you want to hold those leases and not let them expire. And you needed to drill. So they drill a vertical well down to the Marcellus formation, and they put a cap on it and what's called shut it in. It's now shut in exactly on the last day of the 5th year of your lease. And I only reference that because we're going to talk about years and shut in and how long this can last. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each week at this time on this station for All Things Marcellus, and give us a call, learn about representation, or give us a call for representation, regardless of where you're located. 570-307-0702. That's 570-307-0702. So, all right, what do we have? And we'll talk Tioga, but this is the same principle for other places. But this is what's happened. We see it all the time in Tioga County, where Shell, Sweppy, and East before them, drilled these vertical wells that they're not producing gas from. And they're using these vertical wells. They shut them in. They cap them. They shut them in. And they use those to hold or extend the lease after the primary term. So remember, 5 years is what's called the primary term. So within 5 years, they drilled a well. So at the end of 5 years, there's a vertical well that is holding your lease, meaning your lease does not expire because there's been a well drilled. It's a vertical well. A well, in many cases, will never produce any gas. They drill the well, and then they put a cap on it. They shut it in. It's now shut in. And you receive, for each year that it's shut in, there's a negotiated amount or an amount set forward in the lease. Bad leases have the shut-in payment per year as $1 per acre that is shut in. So if you have a 100-acre property and they've drilled a well and they put that property in the unit, and let's pretend we have a vertical well going straight down, shut in, your property is in that unit, you have 100 acres, your payment that year will be $100. Now, some leases will give $5 per acre for shut-in payment. So if that, typically the way it's worded and the way it's interpreted, and the way it should be interpreted, is that within that year, if that well was entirely shut in and no gas was being produced, that landowner, if he has 100 acres, is going to receive a $5 per acre or a $500 payment that year. Some leases have been negotiated and maybe you got $20, and there you'd get $2,000 that year. Now think about that. That's just real quick. A lawyer may know that you can increase that shut-in payment. So just as simple as, let's say $5 and you negotiated it up to $25 per acre, and they shut in your 100 acres, as we anticipate there's a chance, depending upon your area, that they may do. Well, if you have 100 acres at $5 an acre, that's a $500 payment. If you have it at $20 per acre, that's a $2,000 payment. So each year that it's shut in, you just made an extra $1,500. It's not our goal, it's not our target, but it's a way that you make that lease better. So that, having an attorney who knows what they're doing, who can potentially negotiate that, may result in, if that occurs, you're getting $1,500 a year. That happens for 5 years. That's going to be $7,500 more dollars because you negotiated that simple shut-in payment up. And that's just a really, really small side example, but just an example of why we need to make sure that we're getting assistance and maximizing these agreements. We always want to maximize everything we can. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And I ran those first couple segments a little long, so we're going to cut this one a little short, but we're going to come back in the fourth segment. We're going to finish this shut-in. And again, if you're in Tioga County and you're listening, stay tuned. If you're in anywhere listening, stay tuned, but especially Tioga County, because this is occurring. And boy, it's just something it just really drives me nuts. I'll be right back. This is All Things Marcellus with me, Attorney Doug Clark. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each week at this time on this station for All Things Marcellus for you, the Pennsylvania landowner. Well, again, another short segment, so I'm going to jump right into it. We're going to bump right into it. Okay, shut in. So, Tioga County, what we see happening all the time out there. Company East and then SWEPI drilling wells, straight vertical, shutting them in, holding in the property. If you do not have a limitation on how long that can occur for, like say a 3-year or a 5-year limitation saying that, hey, if you shut in my well for more than 3 years or more than 5 years, then if you do that, you're either going to lose my lease or you have to start producing. So in other words, if you do it, you're going to lose the lease if you violate that provision. So that forces them to say, hey, we're going to have to either start producing or we're going to lose this lease, or we need to approach this landowner and try to get a new deal, an extension, an amendment, a modification, which can be an opportunity for you, the landowner. So you need to really look at these shut-in provisions. Now, and this is, if you're in Tioga County, this is directly to you. I am very interested in hearing from people who have shut-in wells that are vertical wells drilled straight down to the Marcellus and shut in, and they've been capped. and you've been getting shut-in royalty payments and nothing else, I'm interested in hearing from you, especially if that has occurred or been occurring for at least 5 years. I am very interested in hearing from you because we want to see if we can help you. We want to see if we can help people like that, in that condition, in that position. Because you're sitting there, think about it, promise these riches and, everything is going to be wonderful. Now here you are, you have a shut-in well for 7 or 8 years, and you've never seen anything but a shut-in royalty, and you signed a lease a long time ago, and it's a 12.5% full deduction. And, it's really not what you bargained for. It's not what you thought was going to happen, and it probably wasn't what you were told was going to happen. But the reality is it's what is happening. And especially the longer you've been shut in, the more interesting I think that situation is. So if you're one of those people, hey, I'd like to hear from you. I'd like to see if we can help you. 570-307-0702. Now, I also want to say, if you've only been shut in for a year or 2 or 3 or even 4, I don't know that there's anything we can do at this time. But if you've been shut in for 5, 6, 7, 8 years or more, I really would like to hear from you. And especially if it's because of a vertical well that's not producing. I think I've said before, as of, I think it was May, there was approximately 124 vertical wells that SWEPI owns, 124 that are in regulatory inactive status, just sitting there, people getting shut-in payments from wells that will probably, my opinion, never produce gas. And I see that as a potential problem. So that's why I'd like to hear from people in those circumstances. Again, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, where I represent Pennsylvania landowners, property owners, and royalty owners. Have not, do not, and will not represent oil and gas companies. So just to conclude on shut-in, if you are in a shut-in and you've been sitting there for a long time or know somebody that's been sitting in there in a shut-in phase for over 5 years, interested in hearing from you, we're trying to explore what we can do to try to help people out in that situation because it just doesn't seem right. Now, does it? We need to see what we can do about that. So I'd love to hear from you, 570-307-0702. And especially we see this happening in Tioga County all the time. And we don't see it happening anywhere near the degree. I don't see it anywhere near the degree, anywhere else in Pennsylvania, like I see it in Tioga County. All right, like I said, we ran over a bit in the first couple segments, as I sometimes do. But I want to just talk real quick to Susquehanna County residents or Susquehanna County royalty owners, landowner, property owners, multi-unit well requests from Cabot. Just a reminder, these things are not as often as typically is the case. Everything isn't as always as simple or as easy as it may appear. And I would highly recommend that before you sign a multi-unit well consent that you seek counsel advice from an attorney who knows what they're doing. We do these reviews and consultations with the multi-unit well request. They usually take an hour to 2 at tops. Many take an hour. And what is right for you literally may not be right for your neighbor. So we need to make sure that you're getting specific advice for you. So if you give us a call, we can see if we can help you out, make sure there's no issues with conflicts of representation, but we'd like to see if we can help you. We want to make sure everyone's getting the assistance. 570-307-0702. All right, that's it for today. Remember, let's stop signing bad agreements, and the landman works for the company, not you, the land owner. Have a great week, everyone.